Liability issues with accidents, incidents, and injuries. Broker. Each state holds licensees to a high standard of law for the responsibility that comes along with their role to the public, including their principals and other professionals in the industry. This is why brokers and agents must carry liability insurance. Such insurance fills the gap between the more general errors and omissions insurance, they're the same thing, but often called by both names, and covers things such as state and municipal law that governs real estate agents, association codes, and real estate licensing, regulations, and policies. Clearly, a broker has a larger role of responsibility to both the public and his agents. The greatest exposure to potential damages tends to center around professional conduct versus slips and falls, for example, which may be more the case in restaurant liabilities. It's important to note that should an agent be sued for a professional conduct, including failure to disclose or discrimination, among other things, the broker will likely be included in the lawsuit, even if he has never met the principal. This is part of the expanded liability risks brokers have to face. Agent. For agents, professional liability insurance is written on a by-claim basis. Some things that are typically not included are fraudulent conduct, causing bodily harm, and robbery. Agents are held liable should they intentionally cause harm or fail to disclose. Other oversights or non-intentional conduct will often be covered by liability insurance. Of course, an agent should always conduct themselves in a professional and ethical manner so that fewer issues arise. Agents who use their car for work, especially to show property in, should have increased automobile insurance. Be sure and tell your insurance carrier that you are a real estate agent using your car for work, and if you have buyers, you will be driving around to look at listings. Buyer-seller. Buyers and sellers may be found liable in certain situations. For instance, if the seller failed to disclose a known defect or material fact that may have caused the buyer to not purchase the home, the seller could be liable for damages. Even though the agent and broker may be included in the lawsuit, in this kind of situation, the liability insurance would likely kick in, and the only person who may be required to pay damages would be the seller. Sellers and buyers have a contractual obligation to be honest and forthright in their communications, or could be held liable depending on the circumstances. If an agent is hurt at the premises of a client's home, for example, the client's homeowner insurance may be an applicable solution. If the harm was intentional, assault, for instance, the client may be legally and criminally liable. Third-party acts, liability limited in listing contracts. According to the listing agreement between the broker and seller, the broker faces limited liability in the event of third-party wrongdoing, regardless if the wrongdoing was intentional, negligent, or accidental. An example may be a vendor. For example, if a painter fell, banged his ladder into a large picture window, and caused it to break, it would be the painter's insurance that would be liable for damages, or the homeowner's property insurance, perhaps, not the broker or agent.